Effective communication for paralegals. As paralegals, effective communication is at the core of our role, especially during client intake calls, where the client's first impression of the firm is shaped entirely by our voice. These interactions rely on three key forms of communication: verbal, nonverbal, and written. Each plays a distinct role, yet they work together to ensure clarity, professionalism, and trust. Verbal communication. Verbal communication goes beyond simply speaking. It encompasses the words we choose, our tone, pacing, and overall clarity. During intake, using straightforward, open-ended questions like, "Can you walk me through what happened?" invites the client to share their story. Avoid legal jargon that may confuse or intimidate the caller. Never assume that a client's vocabulary reflects legal understanding. Meet them at their level by explaining concepts plainly and ensuring they feel safe, respected, and understood, not overwhelmed or excluded. Tone inflection volume and pace tone should remain calm, respectful, and non-judgmental. Inflection adds subtlety and meaning, while volume and pacing impact how your message is received. Speaking too quickly may overwhelm the caller. Speaking too slowly can come off as condescending. A steady, neutral rhythm keeps the conversation balanced and encourages active engagement. Nonverbal communication. Even on the phone, nonverbal cues matter. Pauses, pacing, and vocal fillers, when used appropriately, convey attentiveness and empathy. These subtle indicators reassure the client that they're being heard and that their story is being taken seriously. Written communication note. Taking during intake calls must be clear, objective, and professional. Include relevant facts, names, dates, and events without making assumptions or drawing legal conclusions. For example, rather than writing, "Client was assaulted," the appropriate phrasing would be, "Client reports being assaulted." This distinction ensures neutrality and preserves the integrity of the legal record, supporting ethical standards and effective case evaluation. The 6 B's of communication. To enhance your communication, follow these 6 best practices when speaking with clients. Be ready, know what you need to ask. Be brief, respect their time. Be friendly, your tone sets the tone. Be patient, let them speak without interruption. Be polite, please and thank you matter. Be grateful, build goodwill, even for future contact. Additionally, to strengthen your awareness during phone conversations, apply the LOVER framework, a practical mnemonic for reading between the lines. L. Listener. Pay close attention not only to the words spoken, but also to tone, hesitation, and subtle vocal cues. O. Observer. Watch for changes in breathing, extended pauses, or shifts in rhythm that may signal discomfort. V. Evaluator. Trust your instincts. Some forms of confusion, anxiety, or dishonesty may not be expressed outright. E. Reporter. Accurately document both what is said and how it is said, capturing emotional or tonal context. R. Repeat. Revisit unclear or emotionally charged topics during follow-up conversations to ensure clarity and completeness. This framework helps ensure that nothing critical is missed, especially when nonverbal cues are limited. Greeting a potential client, setting the tone, and introducing your role. Now, let's walk through the beginning of the phone intake process, specifically how to set expectations and manage the flow of an intake call while communicating professionally and ethically. Initial greeting and professional tone. When answering the phone, always begin with a calm, steady tone and a clear introduction. State your name and role within the firm. Good morning, this is Josh. I'm a paralegal at Honest Personal Injury Firm. How can I help you today? A warm professional voice builds early trust and encourages the caller to speak openly, setting the tone for the entire conversation. Clarifying your position and limitations. Once you've greeted the caller, it's important to clarify your role. Let them know that you are a paralegal, not an attorney, and that you can't provide legal advice or make legal determinations. This protects both you and the firm from the unauthorized practice of law and helps the caller understand the boundaries of your role. Providing a legal disclaimer. Include a brief but clear disclaimer early in the call. Explain that the intake process is strictly for attorney review and does not create an attorney-client relationship at this stage. At the same time, reassure the caller that what they share is confidential and protected, regardless of whether the case is accepted. This reinforces professionalism and helps the caller feel safe in disclosing sensitive facts. Explain the purpose of the call. Begin by clearly stating the objective, something along the lines of, "The purpose of this call is to gather information so our attorney can review it and decide what the next steps might be." This reaffirms your role as the fact gatherer and not the legal decision maker. Second, it manages the caller's expectations from the outset. They understand this is an initial conversation, not a consultation, and that decisions will follow attorney review. Invite the client to speak freely. When you're ready to begin, allow the client to start with their own words. A prompt like, "Can you briefly tell me what this call is regarding?" invites them to share their narrative in a way that feels natural. Open-ended prompts like this are extremely effective. They give the client a sense of control and often reveal more detail than a yes or no question would. Once they've shared their initial account, you can begin to narrow the conversation with follow-up questions. Use empathetic and supportive prompts. Finally, remember that intake is not just about gathering facts, it's about how you listen. Since the caller can't see your facial expressions or body language, use verbal cues to show that you're engaged and empathetic. Phrases like, "I understand," "Please go on," or "That must have been difficult," let the client know you're listening and that their experience matters. This type of emotional responsiveness helps reduce defensiveness and encourages full disclosure. The intake form is a generic template used to screen potential clients. It may be tailored to a specific area of law or customized by a particular firm, and it can exist either as a physical document or as part of a digital case management system. Its primary purpose is to guide the intake process and ensure that key information is gathered and documented accurately during the call. When transcribing caller-specific information, begin with contact and background details. This includes the client's full legal name, date of birth, current address, occupation, and preferred method of communication. If the legal matter moves forward, every court form, contract, or communication will rely on these details, so it's important to be thorough. For example, when filling out the form, proofread to confirm the information is accurate. Read key information back to the client and take time to correct grammatical errors. Also, make sure to log the date and time of the intake call. This becomes part of the legal record and may become relevant later if statute of limitations issues arise. Preferred communication style. Ask the client how they prefer to be contacted, whether by phone, email, or text, and at what time of day. Conduct a conflict check. As the client begins describing their issue, input names of involved parties to run a conflict check through the firm's database to check for a possible conflict of interest. If a conflict is identified, stop the intake call and escalate the matter to the appropriate supervising attorney. Document notes neutrally and factually. Throughout the call, maintain a neutral, fact-based tone in your notes. Use phrases such as "client states" or "client alleges," rather than drawing your own conclusions. Avoid speculating or using emotionally charged terminology. Remember, your notes may be reviewed by attorneys, judges, or opposing counsel. Remaining objective in your writing ensures the record remains legally and ethically uncompromised. Explore the legal matter in detail. At this stage, shift from rapport building to fact-finding. Begin gathering details that will shape the legal analysis. Ask for an incident summary. Use open-ended questions like "What happened?" or "Who was involved?" to let the client share their version freely. Pay attention to what they emphasize, where they're uncertain, and how confidently they recall events. These cues assist the attorney later. Classify the legal issue. As you listen, determine the relevant legal category. such as personal injury, family law, or employment. Ask whether the client has spoken to other attorneys or has supporting documents. This helps route the case appropriately and reveals whether prior legal steps have been taken. Identify urgency and deadlines. Ask if anything's been filed, whether court dates are set, or if the client's been served. Time-sensitive details will help you flag the case for prompt attorney review if needed. Spot gaps and ask clarifying questions. Listen for unclear facts or inconsistencies and ask targeted follow-ups. Use closed-ended questions to confirm specifics and open-ended ones to gather detail. Can you walk me through that again? Helps the client stay engaged without feeling pressured. Verify information shared. Confirm important facts as you go. Just to confirm, this happened on the 10th? Clarify vague terms like harassed or threatened by asking what the client means. This ensures accuracy and maintains a professional, respectful tone. Once you've gathered background and incident details, begin aligning the information with the firm's scope of services. Determine if case falls within firm scope. If the case fits within the firm's practice areas, move toward attorney review. If not, politely prepare the client for a referral or closure to protect their interests and maintain credibility. Ask what the client is hoping for. Ask, what kind of help are you hoping our office can provide? This aligns client expectations with legal options and helps attorneys better understand case goals. Gather leads and supporting evidence. Inquire about documents, messages, or witnesses. For example, do you have any texts or emails for Kings, or was anyone else present? These questions support early evidence gathering and attorney review. Clarify vague, biased, or emotional statements. When clients use broad language, like "they humiliated me," ask for specifics. Can you give an example? This ensures factual accuracy and avoids misrepresentation. Identify if follow-up is needed. If key details are missing, explain that a follow-up may be necessary. You might say, "Feel free to email us the photos and we'll add them to your file." Be clear about what happens next, whether that's attorney review or a formal referral. Recap the call clearly and professionally. Before ending the call, offer a brief and neutral summary to confirm the facts. For example, earlier this month you were rear-ended on your way home from work, and the other driver was operating a company vehicle. You mentioned experiencing some neck pain and that your car was damaged. Is that accurate? As the call wraps up, reiterate your role and legal limitations. You could say, "Just to remind you, I'm a paralegal, not an attorney, so I can't give legal advice or say how the case will be handled, but I will make sure all of your information gets to the attorney for review." Clarify what the client can expect next. The attorney will review everything you've shared today and will follow up with you by the end of the week to let you know about the next steps. Lastly, remember to document your notes thoroughly and objectively during and after the call. Make sure to include the date and time of the call, full names and contact information, key facts of the incident, and any deadlines, conflicts, or follow-up needs. Legal, ethical, and professional considerations should guide every intake call. Always introduce yourself clearly as a paralegal. Never give legal advice unless directed by an attorney to avoid the unauthorized practice of law. Return calls promptly. Maintain a respectful and composed tone. Being objective and neutral does not mean communicating without empathy. Document objectively and factually. Avoid commentary or tone that signals judgment. Everyone deserves to be heard without prejudice. Avoid drawing conclusions or using emotionally charged language. For example, don't write, "Client was assaulted" unless a police report or legal determination confirms it. Instead, write, "Client alleges they were assaulted." Verify information without assumptions. Always check for clarity and accuracy. Repeat phone numbers, confirm spellings, and ask questions when something is unclear. Don't guess. Verification protects against mistakes, supports legal review, and ensures the client feels heard and understood. Finally, end the call professionally and reassuringly. Make sure the client understands the process moving forward.